NACDL is the association of the nation's criminal defense bar.
So good afternoon. I want to start by talking about the case. It was actually my first solo jury trial at the Federal Defender's Office, and it was the case of United States versus Chevelle Nesbeth. Ms. Nesbeth, when I met her, was 19 years old, a college student, and extremely distraught about the fact that she'd recently been arrested for trying to bring drugs allegedly into the country in a suitcase handles. When I met Chevelle, the furthest thing from her mind was the possibility that she could ever end up incarcerated. The things that she was concerned about in my initial meeting with her were things like, what will all the other students at school think about me? My name now, when folks Google it, comes up as this person who's trying to bring drugs into the country. What's that gonna look like for the rest of my life? I wanna be a teacher. Am I still going to be a teacher? So it was hard not to think about the collateral consequences of her potential conviction when I first met her, because frankly, Chevelle was the one who brought that to my attention at the initial onset. The stigma of her arrest was the thing that she was immediately dealing with. So she identified as being this very typical 19-year-old college student participating in extracurricular activities, working part-time. She was 19 years old, as I mentioned before, no arrests, no prior convictions. She had family who lived in Jamaica that she liked to visit. And all of the things that could come of going to trial or losing or taking a plea and having a conviction on her record were threatening to take these things away from her, and that was always in the forefront of her mind. Instantly, there were headlines in the news that made her feel the stigma already of having a conviction or having an arrest record about who she was. And because she lived in Connecticut and her case was in the Eastern District of New York, she was facing headlines both in Connecticut and New York and in Jamaica, in her home country. Her name and all of this information was plastered all over the news. So with all of that in mind, we made the decision to go to trial in this case. Fortunately, we lost the trial. I'll never forget the moment that the jury returned the verdict, because her reaction was just so visceral and so emotional. And you could tell that she just was standing or sitting there thinking about all that was about to be taken from her, like all the doors were closing, all the doors and all the things that she'd worked so hard for, all those opportunities, she was seeing them start to slip away. And so now when she thought of herself, who is Chevelle Nesbeth, what she thought of is, now I'm a convicted felon, and what does that actually mean for me? Now, in some ways, it was probably easier for the judge in this case, given what we talked about before, her background, to see Ms. Nesbeth and think, this is a person who I want to try to help. I want to do something to help this 19-year-old girl because she doesn't have any prior convictions, because she doesn't have any prior arrests, and I can clearly see how this is going to affect her life in other ways. But that doesn't mean that even if this wasn't who she was, that the judge and judges across the country shouldn't have to confront the issue of how these collateral consequences are affecting our clients. And I've made arguments about collateral consequences, and other defense attorneys have, for clients with violent criminal histories, for clients who are older, for clients who have spent most of their lives in prison, for clients with very long records, because it doesn't matter. We should be making it for each and every one of our clients, because the effects are the same in the sense that they're detrimental but different and individual for each person. And because there are so many collateral consequences, which is the unfortunate truth of the situation, there are collateral consequences that will affect each and every single one of our clients. So what does this mean? What do we as practitioners do? I think the first thing that was kind of striking, as I mentioned about Chevelle, is that all of the information that I knew about her or about what she was concerned about, what her goals were, came from our meetings, right? So talking to your clients, even at the very initial meeting, about what it is that they are concerned about, what their goals are in life, what their situation is in terms of education, what their situation is in terms of housing. Immigration is sort of a given because we have to do that, and that's mandated by law. But what about all of these other issues? There are collateral consequences that can prevent someone from being able to adopt a child, to the extent that that's going to be on the cards or something that they'd be interested in the future. There are things that they might not even... Sure. So this is just a list of some of the types of things that we can ask our clients about. So one is immigration, obviously. Housing. Is your client in public housing? Will having a misdemeanor record or any type of record affect their ability to remain in public housing or their family's ability to remain in public housing? Mood lighting. Also, education. So in terms of drug convictions, we know that felony drug convictions can impact whether or not a student can continue to receive financial aid, which can change completely their ability to continue their college education, which is something that was particularly notable in Chevelle's case. Travel. There are collateral consequences that say that if you are convicted of a drug conviction, your passport will be suspended for the entirety of the time that you're serving your sentence, and that includes a period of supervision. That was one of the things that the judge in this case took into account, because Chevelle had family in Jamaica. The entire time that she was on probation, she wouldn't be able to travel back there because she couldn't apply for a new passport, and she wouldn't be able to get hers back. And then the other things in terms of, or the one after that, is actually adoption. And as I mentioned before, there are collateral consequences that can affect your ability to plan your family. So building that relationship with clients and really finding out as much information as you can about them, about what their goals are, what their dreams are, what their hopes are in life, because these consequences are long-lasting and they really, really span the realm. So where do we even find the collateral consequences? So the first thing, and fortunately there is a wealth of resources out there, is to consult the databases that are available. In the materials that I sent as well, there's a description of how each of these databases work, but I'm just going to read out a few of them. The National Inventory of Collateral Consequences of Convictions that David Singleton just mentioned, the Civil Impacts of Criminal Convictions under Ohio law, the compilation of federal collateral consequences. There's a lengthy article from the ABA called Internal Exile that describes different federal collateral consequences. Some law schools like Columbia are putting together a collateral consequences calculator, and all of these databases are searchable, meaning that all you really need to do is put in what type of consequence, what type of offense, and find out what the myriad of consequences are that are affecting our clients. And the last one I have up there is the Wisconsin compilation of collateral consequences. So there might be calculators in your different states that are specific to your states. There certainly is a wealth of information about felony collateral consequences. So what does knowing about these consequences mean? It might seem just kind of, oh, well, now I know that my client's in a lot of trouble, that we're just kind of screwed and I just have this wealth of information that's not going to be helpful. But there are ways that we can put it to use. One is in plea bargaining. So in our jurisdiction, we call it a considered letter, but essentially a letter in which you're asking the government to change their charging decision or make a different charging decision based on your client's individual circumstances. I like to refer to it sometimes as my begging letter in some situations. And I like to write out my begging in detail. And I talk about my client's life circumstances, and I talk about who they are as a person. In some ways, it kind of reads as a sentencing letter in the same way that we talk about how we employ narrative to discuss who our clients are. But we're also able, in the context of doing so, to point out what the actual consequences of a particular conviction for a charge might be. And we see movement about this in different areas, particularly in immigration, because of the current administration and because I think some prosecuting offices are recognizing the very detrimental effects that certain convictions can have on immigration or have immigration consequences for it, that they are making the decision to not charge crimes in the way that they have done so in the past, because it doesn't make sense to have a crime that's, someone hopping over the turnstile that could lead to that person being deported. And so some prosecution offices are actually asking to be educated about these consequences so that they can make the appropriate charging decisions. And that's also true in housing. In our jurisdiction, the NYU Law Clinic practices representing people who are charged with what are called petty offenses. And the petty offenses are any offenses that occur on federal land in the Eastern District of New York, and for the most part are misdemeanors or violations. But our clients constantly come in asking, well, what impact is this minor violation, potentially just being in the park after dark, a closure violation, going to have on my housing situation if I'm in public housing? How is this going to show up on my record if I was arrested instead of just being ticketed? We have to be able to know the answers to these questions because they are impacting our clients and they are on their minds every single day, as they should be, as they would for anybody in this room. The other place that this really comes out is its sentencing, and that's what happened in Ms. Nesbeth's case. So judges are not in a position, and this is something that I really struggled with, and I think that the judge in our case also struggled with. Ms. Nesbeth had clearly been convicted of importing drugs into the country in possession with intent to distribute the drugs by a jury. And so the judge didn't feel like he had the ability, or didn't know if he had the ability, frankly, to expunge her conviction. And in fact, judges have tried to do that in federal court with no success. There was another opinion also from the Eastern District, Dove, United States, where Judge Gleason, who's no longer on the bench, tried to expunge the conviction of a woman who had been convicted of healthcare fraud 13 years before she filed a motion to expunge her conviction. For 13 years, that healthcare fraud conviction followed her around, and Judge Gleason recognized that she still, 13 years later, was getting fired from job after job after she tried to become a home health aide worker, trying to help her community, never been rearrested after the healthcare fraud conviction that she received, was an upstanding member of the community, and yet she still could not secure employment. And in doing so, Judge Gleason talked specifically about how all of this was compounded by the fact that Ms. Doe was 50 years old and a Black woman. And yet, when he tried to expunge her conviction, the Second Circuit overturned and vacated his decision, saying that he did not have the jurisdiction to do so. So the judges recognized, and Judge Block, in my case, recognized that they only have so much power. They can't, at least in federal court, expunge convictions that would take away some of the extremely detrimental collateral consequences that our clients face. But they do have power in other ways, and you can get them to think critically about this issue. Judge Block, specifically in making a decision to think about collateral consequences, and probably the most surprising moment in my experience in federal court, I walk in for sentencing. We'd submitted our sentencing motions, and the judge says, "Has anyone read the new Jim Crow?" And I was, obviously, or I had read the new Jim Crow years before. The prosecutor was like, "Who wrote that?" And we begin this discussion about how, just what David Singleton was talking about, how the effects of criminal convictions are, in fact, a new caste system for the same populations of people, for poor people and people of color, for our clients, to keep them in a position not unlike where they were post-slavery. And Judge Block, a white, older male, recognized that. and wanted to understand better how this worked, how it was that he maybe could have something that he could do to prevent this from happening. And so he asked us to write on exactly all of the collateral consequences that would affect Ms. Nesbeth, not just me, but also the government, and also for probation to do research and be able to put that into a probation report so that he could consider it at sentencing. And what he was wondering is whether or not all judges in our courthouse should be considering these collateral consequences when making decisions about sentencing. In federal court, there are sentencing factors that judges have to take into consideration. Why isn't this one of them? And so one of the things that judges can do is craft thoughtful sentences that account for these consequences. One type of sentence might include shorter supervision or shorter periods of incarceration, right? Why does a person need to be on supervision for 5 years just because that's a number that we chose that we liked? If the impact of that would mean that for that 5-year period they won't be able to travel, or for that 5-year period they will suffer other consequences. For instance, because Chevelle was from Connecticut, in Connecticut there is a bar against individuals who want to get teaching certifications if they've been under supervision or still serving some type of sentence in the past 5 years before the application goes in. So in other words, if she was on supervision for a longer period of time, that would delay her ability to become a teacher, to be able to even apply to do so. What's the point of that? Most of the collateral consequences that we see have no have no relation to the underlying conviction. They do nothing to actually help the person be rehabilitated and in fact counter that notion. The other thing that judges can do is depart entirely from the sentencing guidelines altogether, knowing the breadth of collateral consequences that our clients are facing. There was a really good quote that I like from a decision in also the Southern District of New York, right across the river, that says, in fact, beyond the offender's actual deprivation of liberty when incarcerated, a host of other penalties and burdens always attend criminal conviction. To name a few: losses of family life, of socioeconomic status, of employment and career opportunities, diminution of civil rights and entitlements, and countless humiliations and indignities commonly associated with living in confinement. In essence, the court's discretion to depart is a manifestation of the necessity for a just sentencing scheme to include provisions for that reasoned, intuitive judgment. Judges should and must be thinking about these things. Before we get to sort of the bigger picture, I want to talk about another trial that I lost. I promise I have won some trials, where I talked about the collateral consequences for a very differently situated client, again, a drug crime. My client was in her 60s, was from Ghana, and part of what our argument was not so much just that she was an older woman, for which there are certain carve-outs in the sentencing guidelines that talk about age and health and how those can be a reason for a judge to do a downward variance from the sentencing guidelines, which were onerous in this case, but also because of the stigma that she would be carrying back with her to Ghana. This woman who was a fixture in her church community, in the Ghanaian community, was going to have to go back home with the stigma of having been arrested and convicted and spending time incarcerated in the United States for a serious drug conviction. And the shame of that, given her cultural background, and given everything that we tried to educate the judge about in terms of what it was to be a woman growing up in Ghana in this small religious community, was punishment enough. Collateral consequences don't have to take the shape of sort of all of those boxed categories that we talked about. They pretty much can be anything. And when we think about the individual that we're talking about, when we talk about our individual clients, there are so many different types of ways that convictions can affect them. And so talking about that and writing on that and having a professor at Columbia talk about the cultural significance of the things that we were discussing in relation to our client helped convince the judge to depart 40 months below the bottom of the guidelines. And I think that we just have to be mindful of all the ways that we can fight back against this, even if it seems impossible. And so just in terms of the bigger picture, again, forcing judges to engage in the broader picture that collateral consequences have, that it is creating a new caste system, and it has been doing so for some time. Then asking judges to really think about how these consequences are frankly often unrelated to the crime for which client was convicted and therefore serve no purpose. There's a notion of, I've done my time, and so I should have the opportunity to be able to start living again, because that's what it really is. The confines of these collateral consequences are literally preventing our clients from being able to live in society. And yet, judges expect them to go back into society and become productive members. They expect them to work. They expect them to be able to find housing somehow easily. They expect them to be able to be successful. And yet, these collateral consequences are robbing them of all of those opportunities. Completely counterproductive to rehabilitation. I'd also encourage folks to read the Model Penal Code's recommendations. I mentioned them in my submission to Judge Block, in part because even though we're not there yet, there should be a mechanism in which judges are able to do something about this, to do what Judge Gleason was trying to do with Ms. Doe, which is expunge convictions, be able to give people the opportunity to get that rehabilitation and become part of society in the way that they absolutely deserve. There's no reason why 13 years after her healthcare fraud conviction, Ms. Doe should still be getting fired from jobs after job after job. So we do have power in these circumstances, and I would just ask everyone to consider that, despite the sort of grimness that comes with knowing how many collateral consequences there are out there. Yes, she was facing a sentencing guideline range of 33 to 41 months.
And can you tell us what her sentence was?
1 year probation.